Hello. First, I wanted just to remind you where we're up to. We've talked about a contract being a bargain, that there is an offer and an acceptance of that offer. The other factors that a contract needs are involving the status of the person who offers and accepts the offer and whether there's any mistake in law or in the factual sequence, or things intervene unexpectedly, or there's a lack of consideration. Well, today we're going to look at the issue of consideration. So you need an offer, you need acceptance of that offer, but you need sufficient consideration. So the objectives of the revision we're doing today is you should be able to identify whether there is any consideration within the bargain, whether the potential consideration is sufficient consideration, and if there is sufficient consideration for the agreement to be a contractual arrangement. Consideration must be something of value. It needs to be sufficient consideration, but it need not be adequate consideration. That's what we call a maxim or a general rule. What do we mean by that? Well, let's start at the beginning and consideration must be something of value. It doesn't necessarily mean that it has to be something of monetary value. It's something that the other side needs or values. So if one side's making an offer and that offer is accepted by the other side, the reason that offer is accepted is because they perceive that the thing or what has been agreed is of value. It needs to be sufficient, but it does not need to be adequate. In other words, it's not for the courts to determine what is a good bargain and a reasonable price against what is a bad bargain. Let's look at the case of Thomas and Thomas, 1842. In this case, Mr. Thomas made a will leaving all his property to his brothers, and he left nothing to his wife. He did, on his deathbed, express a wish that his wife would be allowed to live in the house for the remainder of her life or receive £100 from his estate. Now, that expression didn't form part of the will, so she couldn't enforce it through the will. However, the people who administered the will did give the lady, Mrs. Thomas, the right to reside in the house, provided she paid £1 per year for the rest of her life. And she started to live there. Now, the problem was the brothers, or one of the brothers, wasn't happy with that. He wanted to take possession of the house, take it off her. But he couldn't because of this agreement between the executors and Mrs. Thomas. Now, the question the court had to determine was the agreement a contractual agreement, and had Mrs. Thomas provided sufficient consideration? Remember, consideration needs to be sufficient, but it need not be adequate. So we'll see what happens. The brother, through his lawyers, argued that the wife paying £1 per annum in ground rent was an insufficient consideration because it was well below any reasonable market rent. The court looked at it on this basis. The court determined that consideration needs to be something of value as opposed to a gift. Well, in this case, a pound, especially in 1842, wasn't a small amount of money. Although the lease of the house for £1 per year was well below any market rate, for consideration to be sufficient for a contract to be valid, it just needs to be of some value. It was not for the courts to set a minimum value if some consideration was provided. Therefore, Mrs. Thomas was allowed to live in the house as long as she paid £1 per year. She got a life interest in the property provided she paid £1 a year. Bit of extra knowledge here you may find helpful if it comes up in exams. If the will, the written deed contract, it's a deed because it's witnessed in front of witnesses and it's signed. If the will had specified that she had a life interest in the property, i.e. that she could live there for the rest of her life, but then the property would revert back to the brothers, then because the will is a deed and does not need consideration, then she would not have needed to provide any rent at all. And at her death, the property would have gone back from one brother to the other. One wonders why whoever drafted the will didn't tell Mr. Thomas before he died this and protect her and stop her having to pay £1 every year. In the case of Thomas and Thomas, we were talking about a small amount of money. In the case of Chappell and Nestle, the House of Lords, which is now the Supreme Court, but it was called the House of Lords in 1959, the case was about some money, but also the value of Nestle's chocolate wrappers. Let me explain. 1959, the offeror, in this case Nestle, offers something of value to the offeree, and that means the people who acknowledged the offer and responded to it in the advert. What they did, they advertised, Nestle, a promotion to sell more chocolate. That's what their aim was. The promotion was, if the customer paid 1 shilling and sixpence, that's in old money, by postal order, and also provided 3 wrappers of a Nestle chocolate bar, the consumer would be given a record. Now, that may not be familiar to you, but there are some records still about. There is vinyl about, but we're talking about a single, a record which young people wanted in 1959 to play on their jukeboxes or their record players. The record normally retailed for 6 shillings and 8pence. So let's do some conversion. 1 shilling and sixpence is about 14.5p, and 6 shillings and 8pence is about 66p. So there's a big difference between 14.5p and 66p. Chapel didn't answer the offer, didn't send in wrappers, wasn't concerned with making the offer and getting the record. What his concern was, he was the owner or one of the owners of the copyright on the record, and as such he was entitled to a small percentage of the normal retail price of the record from Nestle for each record given away in the promotion. Nestle didn't want to pay him copyright at £6.08 or 66 pence, the percentage of that. What they wanted to do is pay a small percentage of 14.5 pence, which is considerably less. The issue the court had to decide was whether 3 wrappers constituted part of the consideration, as in fact the wrappers, once counted, were thrown away by Nestle. The House of Lords looked at this and they did find some value for the wrappers. And you might say, well, how could they do that? They were worthless. But you see, they weren't worthless, and the House of Lords recognised that, because what Nestle were trying to do was they were trying to get customers to change their chocolate brands and buy more of their chocolate brand. Because of this, the wrappers were like a token and had a value. And therefore, Chapel was able to obtain an injunction to stop the promotion and prevent the record being discounted, because the value of the wrappers were of value, but the value was indeterminate. They couldn't say how much, and therefore they couldn't calculate what he was entitled to in copyright. Bit complicated, but let's try and explain it in a pictorial way. So the customer, we can see, sends 1 shilling and 9 pence and 3 chocolate wrappers to Nestle. In return, they get a hit record which would normally have cost them 6 shillings and 8 pence. So they receive that. So they get something for something. So clearly there is consideration. Now, what happens if they just paid 1 shilling and 9 pence and didn't produce any chocolate bars, and they were just given records at that price? Well, there would still be consideration, but it wouldn't benefit Nestle at all. They would just be giving the record at a lower price than the retail price. They didn't get any benefit. So the way they measured the benefit was by requiring the customer to produce 3 chocolate wrappers of Nestle chocolate bars. That meant they could be sure that the customer had purchased 3 chocolate bars from them, and that would increase their sales and might cause them to eat Nestle's chocolates all the time for the future. So they were effectively investing in the promotion. So it couldn't be said, the court determined, that the wrappers were worthless, and that they did, and it was said that it did constitute some value and formed some part of the consideration. because the wrappers proved that the promotion was encouraging the purchase of more of their chocolate bars. The next thing I wanted to discuss with you was privity of contract. It is part of the consideration of who is a party to the contract, because that's what privity is about. It's about identifying who are parties to the contract, because only the parties to the contract can rely on the terms of that contract and have the right to sue the other side if they don't fulfill their obligations in the contract. Let's look at this case, Price and Easton, 1833. This involved doing some work. Easton reached an agreement with X that if X did some work for him, Easton would pay Price £19. Why would he do that? That's your first question, isn't it? Why would X do work for Easton and not be paid, and instead be happy that Price was paid for the work he did? Well, there may be a lot of reasons why X agreed to do that. Let's speculate a bit and think of some reasons. Well, number one, X could have owed Price £19, and by Easton paying Price £19, he could have cleared his debt, and effectively providing the work to Easton cleared his debt that he owed Price. That might be a possibility. Or he may be helping Price out because he's a relative or a dear friend, or he's struggling and it's as an act of charity. So we don't necessarily know why X agreed to do the work provided Easton paid Price, but clearly he had his reasons, or she had her reasons. We don't really know if it's male or female. The problem arose with the contract when Easton did not pay Price £19, and Price then sued Easton for the £19 he was owed, or she was owed. £19. Now, what's the problem with that? Well, X and Easton were the parties to the contract, not Easton and Price. So Price didn't have what we call a cause of action. Price was not part of the contract with Easton. Price was to receive the benefit, but the contract parties were Easton and X. So point one, Price didn't provide any consideration to Easton because it was X who did the work. The court looked at this point one and decided the case must fail on this point, so they held that there was no consideration provided by Price to Easton. But you can also interpret it on the basis of privity. The parties to the contract are Easton and X. Price isn't a party to the contract. If X therefore had sued Easton as a party to the contract he provided, the work for a promise by Easton to pay price, then his provision of work would be something of value and would be proper consideration. So X could have required Easton to provide the consideration he promised. And he was the person, X, who should have sued Easton. I know it can get confusing when we start talking about three different names, but let's look at it on a storyboard to try and make it look a bit clearer. So here's a picture of Easton, and here's a picture of X. Easton agrees with X that X does some work, which we've shown to be manual work in this case, and that's what the tick means. And he agrees, that is, Easton and X agree together that if he does the work, Easton will give £19 to Price. So that's point number one. So looking at this, who are the parties to the contract? X and Easton. What was the promise that Easton made to X? Well, he promised to pay Price £19 if X did the particular work that Easton wanted done. X completed his side of the bargain, but Easton didn't and withheld the money from Price. Because the wrong person sued Easton, Price sued Easton, because of that mistake, Easton got away with paying the £19 to Price. But if X had sued Easton, there wouldn't have been a problem, because Easton could have enforced the contract. X could have enforced the contract against Easton because he was a party to the contract. So only parties to a contract can enforce the contract. That's the general rule. Price, not being a party to the contract, didn't provide any consideration to get the £19 and was not able to sue properly and get Easton to pay her. In this case, Collins attended and gave evidence at court on behalf of Godfrey, a witness for him. Godfrey had promised to pay Collins a sum of money if he attended and gave evidence. Collins had to attend and give evidence in any event because the court ordered him to attend by the use of a witness order, sometimes referred to as a subpoena. After giving evidence, which he was required to do, Godfrey didn't pay Collins the sum of money he'd promised, and Collins sued for it. The court held that Collins was already required to attend because of the witness order, and as such no consideration had been provided by him for the promise of attending and giving evidence. because he was required to do it through the court order in any event. So he provided no consideration, therefore there was no contract. Past consideration is no consideration. That's another maxim. Let's remember that one. Past consideration is no consideration. So what do we mean by past consideration? Well, we mean that some contractual thing has already taken place. So if we went back to the previous case of Collins and Godfrey, and we looked at changing the facts slightly and said that the promise to pay by Godfrey occurred after he'd already given evidence on behalf of Godfrey, then clearly that would be unenforceable because he'd already given that evidence, so it was past consideration. Past consideration is no consideration. But in that case, the promise was made before he gave the evidence, and therefore it was potentially valid consideration, but we know it failed on another reason because he was already required to attend. It wasn't of consideration, there was no value to it. Let's talk about one of my favourite cases. It's a very old case. It's called Stilk and Merrick, and it's in 1809. It involves the captain of a merchant ship who had a crew sailing from Britain to America and back again. Now, the first part of the journey from Britain to America went reasonably well. They arrived at the American port, but some of the 12 crew jumped ship. What do we mean by jumped ship? Well, they failed to stay with the ship for the return journey. They disappeared and started a new life in America. Now, they were contracted. The agreement, which was normal in those days, was for the merchant marines, the seamen, to be paid full amount when they arrived back at their home port. So they wouldn't get paid fully. Remember, a roof was over the head through the ship and they got fed. So they wouldn't get paid until they arrived back at the end of the voyage, going from the UK to America and back again. But they all agreed that they would work at the start of the contract and that they would be expected to cover for situations and emergencies as part of the contractual agreement. The captain, in this case, offered the crew a bonus at the end if the crew agreed to work extra shifts and extra hours and work harder to get the ship home with a reduced number of sailors. They did it. The ship came safely back to port. The owners, hearing what the captain had promised, thought, hang on, we didn't agree to that. We don't think we should pay the crew for doing something that they'd agreed to do anyway. The contract stipulated that they were to work to the exigencies of the journeys, the voyage, and if there was a shortage of crew, which often happened, they would cover for that shortage. So the crew had already promised at the start to crew for the voyage, and that's what they did, and that there was no additional consideration other than the one that was provided at the beginning. So they were owed what they were owed as part of the written agreement at the beginning, but they weren't entitled to the bonus offered by the captain for working extra hours on the voyage back and covering watches, etc. I've used the word watches, so I better explain it. A ship obviously needs to be have lookouts 24 hours a day. It's normally divided into 8-hour shifts, which is called a watch. So when one watch is on, the other two are off duty and resting, but available if they're needed for any emergency. And as each shift takes over after 8 hours, another shift comes on, and then the other shift had been there comes back off again. But they can all be required to all hands on deck and deal with a crisis if they needed to. That's the way ships worked in those days. All hands on deck. Remember what we're talking about here. Past consideration is no consideration, and Stokel Merrick establishes the principle that if you have already agreed to do something, because someone offers you more money because you're reluctant to complete the contract, that generally will be no new consideration. If you're wise, you've noticed I've used the word generally, because I'm going to talk to you about another case in a second. This case, Williams and Rafi, 1990, involves a builder and a subcontractor joiner or carpenter. The builder, Rafi, contracted with Williams to do the joinery work on a house he was building for a client. In fact, it was several houses, but we'll just talk about one for now. Williams had underestimated the cost of the work, and he was struggling to complete the job. Now, Rafi knew that if Williams became bankrupt and couldn't complete the job, Rafi would need to find a new joiner and risk a delay while the job was completed, which he couldn't afford. The reason why Rafi couldn't afford it is because the contract he had with the person they were building the house for had a penalty clause in the contract that said, we expect you to finish on such and such a date, and if you don't finish on that date, you will incur a penalty per day off the price. So the price would go down effectively, and Rafi would lose money. So Rafi, realizing that Williams was close to bankruptcy, decided to offer Williams extra money to ensure the job was completed on time. In other words, keep him afloat and make sure that the job was completed. Well, the Stoker-Merrick argument is past consideration, there's no consideration, and they'd already agreed something, and he was only doing what he was required to contractually do. So on the theory that was on Stilk and Merrick, Rafi shouldn't have to pay Williams the money that he promised, because past consideration is no consideration. But the court held no. Rafi avoided a detriment, so there was something new, more than the previous consideration. Williams was entitled to go bust and say, I can't do it, and he would have lost the money and he would have gone out of business. But he didn't, and he relied on Rafi's promise of extra money to allow him to complete the job on time, so that Rafi didn't get penalised through the penalty clause in the contract. The court looked at this and decided this was extra consideration or new consideration, because Rafi avoided a detriment and Williams, in reliance on what Rafi promised, avoided bankruptcy and carried on working based on having the extra money to complete the job and get the job done on time. So, what does that tell us? It tells us that the courts, when considering consideration, will look very carefully at whether there is any new consideration, and they will look at who's relied on the promise and who suffered a detriment because they relied on the promise, and who's benefited because someone relied on that promise. Sometimes this is referred to altogether as the common law of obligations. That's not my phraseology. That's a phraseology from a famous book by John Cook, who was a lecturer at Liverpool, John Moores University, a senior lecturer. Because you can get offer and acceptance and consideration, but you need to consider if the consideration is sufficient, if the consideration is past consideration or current consideration, and is it sufficient to make the deal complete and satisfy a contract. And in making those inquiries, you need to look at very carefully who's benefiting, who's providing what in return, and whether the parties it's suing are in fact the parties to the contract. Thanks for listening. I hope this was helpful. Bye.